I beg to mention item number 10, Your Lordship, with the consent of the appellant side.
Yes.
Item number 10,
Yes.
only 2 each time may be invested.
18 matter. Here for whom?
Respondent number 1,
On a prayer made on behalf of the respondent number 1. Matter is adjourned by a week. 1 week. Not 2 weeks. 18 matter. Yes.
May I please, your lordship? So with the consent of others, I beg to mention item number 8, lordship.
Yes.
Can it be taken on 8th of August, lordship?
17 matter. Why?
Lordship, my senior is not well. Last few days he's suffering from spondylitis, lordship.
Okay, who is your senior?
P. Mahanta.
Okay. Yes.
Can it be 8 matter?
It is submitted that P. Mahanta learned counsel for the petitioner, for the appellant. Appellant is not well, and therefore adjournment has been sought for. List on 8th of August.
Obliged.
This will come up for order Friday or Monday. This is regarding like civil division petition. I am the respondent. They have explained the matter. It has been granted by the court. I file a petition for vacating. It was listed on vacation, but thereafter not listed.
Friday.
May I please, lordship? Lordship, I beg to mention for listing on RSL, lordship. It's a 2010 matter, lordship, on Friday, lordship.
Lordship.
Let me lordship, this matter, IS will for release of the amount deposited by the interest group. Maybe listed on third,
Third means?
Thursday,
Thursday.
lordship. Earlier it was listed 2 occasions, but not
Okay.
this.
Lordship, item number 10, they mentioned, lordship, not after a week, after 2 weeks, lordship, my senior will not be there next week, lordship. So, lordship, can it be after, after
18 matter. 2 weeks.
Lordship,
Item number 10.
if possible, Lordship, kindly Friday, please. Friday,
You have said you want adjournment
yes, Lordship.
for 2 weeks.
May I please, your lordship? Lordship, I beg to mention a RSA matter for listing,
Matter of which year?
2017,
When do you want?
next week. Obliged.
My pleasure. This matter, my lord, it was, my lord, mentioned several occasions. And in fact, my lord, applications were also, my lord, submitted before the registry. On the last week, your lordship, my lord, permitted to list this matter on Monday, yesterday, my lord. But it has not been listed.
Matter of
More on-
RSA,
RFA,
RFA. Which year?
2017.
17.
My lord, last order was 2018, and it was fixed in the
Okay,
month of
okay.
2018.
Well, Whenever you want. Friday
My
or
lord.
Monday?
My lord, I beg your lordship special indulgence because my lord, in spite of my lord repeated mentioning.
We
it has
can,
not been
pass
listed.
this, only one equal, similar order in a mention memo.
My-
You file an IA.
Fine.
You file an IA, get it listed. We'll have the IA.
If my lord on Thursday it is not listed, my lord, in the circumstances, I will file.
You want, presently, you want listing for what purpose?
For orders on
Orders.
Thursday, my lord, for fixing it for hearing.
Not Thursday, put on Friday.
Right. Obliged.
Yeah.
May I please, your lordship? Your lordship, I'd like to beg to mention 2 interlocutory applications, your lordship. The matter may be listed on Thursday.
Thursday is difficult. IA for what?
One for release of the payment deposited in an MEC case, and another so your lordship, it is an appeal by the insurance company, and they want to stay the order, and we are the respondents here in the second IA, your lordship.
Okay, we can have it on Thursday.
Obliged,
Has the
lordship.
money been deposited?
Yes, in the month of January itself, your lordship.
You're for the claimant.
I'm for the claimant.
I beg to mention for listing of the case, RSA, my lord, 18. My lord, what happened, my lord, civil just record was come, but since 21, the municipal record is not. So remainder is also same. This case is pending for a long time, so it may be listed in order, so appropriate.
Next Monday?
May I please, the lordship? Lordship, I beg to mention RSA of 2017. Lordship, the matter was substitution of appellant of number 1. Lordship, matter may be listed on 4th.
Fourth we have finished. Big lot of matter. Have it on 7th. 7th of August, Monday.
Lordship, can it be after 7th because my senior
Okay, the
will
9th.
Much obliged.
Hey, please, your lordship. Lordship, I'm beg to mention an item for fresh listing. The matter is first appeal against an order,
Press listing.
fresh listing.
When did you file?
On day before, your lordship.
Day before appeal will not come immediately. Is there any urgency?
Yes, your lordship, the matter was remanded back to the trial court for cross-examination of witnesses. And the matter is fixed on this fifth, this Saturday. Therefore,
Okay, we will have it on Friday.
obliged.
May I please proceed with the question of other party? I beg to mention item number 4, Lordship.
4.
Yes, Lordship. Senior counsel agree focus to is next in court number 5, Lordship, in the part of matter, sir. It will take all the day, Lordship.
My lord, I have no difficulties, my lord. Only he, I think he's only.
Item number 4.
4 years.
Who is your senior?
AK focus, Lordship.
When do you want?
My lord, I wanted at 2 o'clock, but he said he won't be able to finish it. Because my case is urgent, my lord, that's why.
Arrested.
Yes, my lord.
Arrested.
And there's a IA also.
IA for what?
IA for permission to take permission for selling the land, part of his land, my lord. Because his wife is suffering from cancer.
Okay, we'll have it on Friday?
Yes, my lord, my lord.
No, not Friday, day after tomorrow, Thursday.
Thursday, my lord.
Lordship, Thursday he will be out of station.
Friday we have finished a lot of matters.
My
Friday,
lord, Friday, can it be on top of the list, my lord?
Friday we have fixed a lot of matters. Friday it may be difficult.
My lord, in order, top of the list, my lord.
Lordship, on
Friday we have already fixed a number of matters. Friday it may not be possible. Have it on Monday?
Lordship on 7.
On Monday?
Yes, Lordship.
Thursday, close. No? Thursday, close. No, Thursday.
He's very out of station.
Yeah, I'll just keep it.
No.
Monday, Monday.
7.
7. Obliged, Lordship.
Oh,
Item number
4.
4. On a prayer made on behalf of the appellant, matter is adjourned to be listed on Monday next date.
Monday, can
7.
it be on,
7.
top of the list?
We
in
cannot
order,
say.
my lord?
It comes chronologically. It is
Yes,
17 matter, it will come up, don't worry.
Yes, Lordship. Obliged, Lordship.
My previous lordship. Present division is filed by the minor, the plaintiff landlord against the reversal of the finding as regard to the default. The London trial court has decreed the suit both on the ground of the defaulter as well as the bona fide requirement, my lord. And in appeal filed by the defendant tenant, the finding as to default was reversed. As the appellate court's judgment, my lord will find
Petitioner is the landlord.
petitioner is the landlord, my lord.
LCR has come.
Yes, my lord. So firstly, may I take your lordship to the appellate court's judgment, which starts at page 56, my lord.
This will take some time, I think.
Yes, my lord.
This will take some time. We'll go in for disposal.
Yes, my lord.
This matter will take some time. Other members may come after, say, at least 40 minutes. For 1 hour. Petitioner is the landlord
Yes, my lord.
and you are the plaintiff.
I am the plaintiff, my lord.
Suit for ejectment.
For suit for ejectment.
Grounds,
Ground on bona fide requirement as well as defaulter. These are the two primary ground, my lord. Although the ground of sublet was also taken, that was negated.
then trial court,
Trial court had decreed the suit on the ground of default as well as on the ground of bona fide requirement.
both.
And in appeal,
Okay. Appeal,
in appeal, the ground of default was reversed. So as against that finding, the plaintiff has preferred this revision method, being on the ground of perverse and illegal.
but bona fide ground is there.
Yes, ma'am.
So ejectment decree still
It
stands.
still stands.
And their revision petition is against
They have challenged both default and the the trial court judgment as well as the judgment of the appellate court.
Appellate court judgment is only to the extent of upholding bona fide.
Yes, my lord.
In first appeal, there, one of the grounds they have, it's in their
Yes,
favor.
yes, my lord.
Yes,
So my lord, first may I take your lordship to appellate court's judgment, my lord, which starts at page 56. Page 56 it starts, and issues are framed on page 61, my lord, will find the issues on page 61. Point for determination.
page 56.
Page 56 judgment starts, my lord, the impugned judgment.
Ready for one.
Yes, my lord.
Yes.
So the issues for
At
page 61. Issue number 2 at para 10 subclause 2, whether the defendant is defaulter in payment of rent, and whether the plaintiff number 2 and 3 are entitled to get atoned new tenancy agreed by defendants in respect of the suit premises with the plaintiff number 1. And 4 was also taken up together, whether defendants are liable to be evicted from suit premises.
okay.
And issue number 2, the ground of defaulter was discussed at page 62 of the impugned judgment. My lord.
Which point?
Point 2 at para 13, page 62, down below. May I read it to you? It's
Yes.
small para. The pleadings and the evidence of the parties reveal that the payment of rent is not the main issue between them. Rather, execution of new lease agreement upon new terms and conditions is the main issue. Nevertheless, let us see if the allegations of plaintiff as regard non-payment of rent by defendant on time is correct. If we peruse materials available on record, we will find that the paragraph numbers 6, 7, 9, and 15 of the plaint, coupled with cross-examination of PW1 and Exhibit B documents, particularly entry dated so and so, adduced by defendant, categorically reveals the plaintiffs were in practice of taking area rent together initially, but later on they themselves had refused to accept up-to-date rent tendered by defendant and had also returned the rent to the defendant for not attending new lease agreement upon new terms and conditions with plaintiff number 1 in respect of the suit premises as per their wish and for which defendant had to deposit the rent in the court. Now, if that be the position, then I am of the considered opinion that the defendant cannot be termed as a defaulter in payment of rent because it is the plaintiffs themselves who had refused to accept the rent. And we now know that it is settled proposition of law that the parties cannot be allowed to take advantage of its own wrong. In the light of principle of nullus commodum capere protest de injuria sua propria, that in the light of principle of equity, that he who seek equity must do equity. The plaintiff ought to have accepted the rent and had approached appropriate authority for enforcing their right to get renewed lease agreement upon new terms and conditions. So in the above backdrop, I am of the considered opinion that the claim of the plaintiff that the defendant is a defaulter is not justified. Accordingly, the point is decided in negative and against the plaintiff respondent. Consequently, the decision of learned Munsif in respect of this point is also set aside. Now, may I take your lordship to the trial court's judgment as how this has been dealt with.
What was the evidence here?
Here, my lord, initially tenancy was created by the petitioner plaintiff number 2 in our own name, the Kanta Devi Jain. Subsequently, my lord, this Kanta Devi Jain, along with his son, the plaintiff petitioner number 3, has formed a co-ownership, and that was intimated to the defendant, to which they have replied, they have accepted. But in spite of that, they have continued to send the check in the name of the erstwhile plaintiff, not in the name of the transferee plaintiff. And it is categorically they have admitted in their evidence in chief as well as in cross-examination that for 8 months together, from the month of April 2011 to November 2011, they have tendered without tendering the rent, they have deposited in the court. For the month of April, May 2011, as well as July 2011, they have sent the check in the month of August, in the name of the erstwhile landlord, that is Srimati Kanta Devi Jain, as against
No,
as such.
there are two issues. One is whether the rent was tendered at all.
At all,
Number two, whether
it was
rent is
lawfully
tendered. No, we are not going into that aspect. That is aspect we'll go into.
Yes.
But now it appears that there was a change in the ownership.
that was
Now,
intimated.
from one individual, two individuals became the owners of the property.
Yes.
And this was intimated to them. Is it your case that only because the check or the rent was paid in the name of the erstwhile owner, he becomes a defaulter? Or is it your case that apart that the rent was given in the name of the erstwhile owner, that was never tendered to you and it was directly deposited in the court?
No. That is an admitted fact, my lord. That check for the month of April 11, June, July. For the month of April, May 2011,
April
11 to May 11, and June 2011 and July 2011.
April to July.
April to May in one check for 2 months together. I had one check, that is Exhibit X. It is on
April,
record.
May, one check.
Yes, my lord. And for the month of June 2011 and July 2011, I had another check, which is Exhibit Y.
June and July.
Yes, my lord. They have tendered together in the name of the erstwhile landlord Kanta Devi Jain.
Okay.
So, since it was sent in the name of the erstwhile landlord, it was returned. And secondly, there is no evidence that for the month of August, September, October, November, that the rent was tendered and offered to the landlord, either to the erstwhile owner
August,
or to the
September.
transferee owner.
October, November.
Yes, August, September, October, November, 2011.
Rent was not tendered.
Never tendered, it was deposited in the court, and that will, my lord, will find from Exhibit C. And they are in their evidence in chief also, they've admitted that for 8 months together from April 2011 to November 2011, for 8 months together, they have deposited the rent in the court.
No, so far as till July is concerned, it was tendered and refused.
Refused.
They have the excuse. But from August to November,
No offer and tender.
it was not tendered.
No. So they cannot seek protection under 5(4) without compliance.
What was the proof regarding tendering? Did they use any evidence that it was tendered to you?
No, my lord. They have DW1 has adduced that Exhibit X and Y for April, May, June, July in the name of the Kanta Devi. That apart, they have not adduced any evidence to show that for the month of August 2011 to November 2011, either it was tendered and offered in the name of the erstwhile landlord or to the transferring landlord. Neither of them. So may I take your lordship to the trial court's judgment on the ground of how the point of default was dealt with.
Yes.
It starts at trial court's judgment starts at page 36, my lord. Issue number page 36, judgment starts at page 37, and my lord will find issues at page 43, issue number 3 and 4. And defaulter is
This is dated 4 June.
3 and 4, whether the plaintiffs are the new landlords and legitimate co-owners of the tenanted premises, and whether the defendant number is a defaulter in payment of rent. Page 40, my lord, of the trial court's judgment issues.
40.
Issues, my lord, will find at page 43. Sorry, page 40.
Yes.
And at page 43, issue number 3 starts. Whether the plaintiffs are the new landlord, my lord, this will find at page 43, down below, at paragraph 15. May I read from page 44, my lord, the issues number 3. Page 44.
Yes.
As regard to this issue, the PW1 Anil Kumar Jain has stated that initially the suit premises was given on rent by Srimati Renu Devi Jain. The agreement between Renu Devi Jain and the defendants is not submitted before the court, and her name is also not mentioned in the plaint. The suit premises were not acquired by the plaintiff from Srimati Renu Devi Jain. Then said suit premises were acquired by plaintiff number 2 from his father, late Ratan Kumar Jain. PW1 has deposed that Srimati Renu Jain is not a owner of the said farm, and there was a property dispute with his mother, Srimati Kanta Devi Jain, for which the said co-ownership farm was formed by PW1. The PW1 has accepted the fact that it necessary to execute a fresh agreement between the co-ownership farm and defendants. In Exhibit 9, it is written that as the checks are addressed to plaintiff number 2 instead of plaintiff number 1, for this reason the check was returned. Moreover, the rent were not offered on time by the defendant. The PW1 denies the system of receiving rent together for several months. Whereas the DW1 Utpal Rajbanshi states that the Exhibit A lease deed dated 1/12/94 is still in existence, and there is no necessity of executing a new lease deed with the plaintiff, and the defendant number 1 company has deposited the rent as per the said lease agreement. The DW1 has admitted the fact that the plaintiffs filed Exhibit 3, that is letter dated 25/1/2011, informed the defendant number 1 that on or from 16/9/2010, the co-ownership firm, namely Messrs. Kanta Devi Jain and Anil Kumar Jain, has become the owner. This is important, my lord, of the suit premises, and thereby asked the defendant number 1 to atone the tenancy and paid the rent accordingly to the said plaintiff number 1. The TW1 has clearly stated that defendants had sent a reply to the said letter. They have even sent a reply of plaintiff, and on 25/4/11, another letter was issued by the plaintiff, asked the defendants to execute a fresh deed of agreement on mutually agreed terms and conditions. On receiving such letter, the defendants had sent the rent for the month of April and May in the name of Kanta Devi Jain and Anil Kumar Jain. This is not correct, my lord. This finding is wrongly recorded. For this, may I take your lordship at para 6, next page 45. This will clarify. Yes, para 6, page 45. As per Exhibit 3, may I read, lordship? Page 45,
Just a minute.
clause 6. Next page, my lord, page 45, para 6. Only for clarification of that part. As per Exhibit 3, defendant number 1 has been asked to atone the tenancy and to pay the rent in the name of the plaintiff number 1. But in spite of receipt of letter from the plaintiffs, the defendant number 1 had sent the rent for the month of April and May 2011 in the name of Kanta Devi Jain alone. And this will be further put from Exhibit 6, Exhibit X, might.
Okay.
Now again, may I take the lordship, page 44.
Yes.
When the said rent to check X and Y, have you lordship got it in the middle? On receiving such letter, the defendant had sent the rent for
You're
the.
reading 44, isn't it?
Yes, now I'm again coming back to page 44, my lord, in continuation.
Middle of paragraph 2.
Yes, middle of the paragraph 2, my lord, from Exhibit X and Y, if your lordship find it in the middle, from the bottom. Seventh line from the bottom.
Rent takes X and Y. return
Yes, my
back.
lord. Exhibit X and Y returned back the rent for the month of April and May was deposited in the court in the month of December, my lord. even if it is refused in the month of August, within a fortnight, they ought to have deposited, but it is their own admission that in the month of December 11, they have deposited.
December
Yes, my lord, December 2011.
2011.
Yes, my lord. Further, the DW1 has stated that he requested Srimati Renu Devi Jain to let him know whether the rent should be paid to the plaintiff number one. The version of DW1 is clearly reflects the picture regarding the ownership of the tenanted premises. The defendants nowhere refrain from accepting the ownership of plaintiff number one and other plaintiff. The defendants had approached to Srimati Renu Devi Jain and requested her to let him know whether the rent should be paid to the plaintiff number one, that is the co-ownership firm. This act of defendants transpires that the ownership of plaintiff number one has already been admitted by the defendants by sending the check in the by replying the letter. The defendant never disputed the ownership over the tenanted premises. And they are also well aware of the formation of the co-ownership firm. In their evidence, their objection as regard to the ownership of the plaintiff is not reflected. Moreover, nature of this suit states that the main dispute is related to default in payment of rent by defendants and arrear rent. The plaintiff number one is an artificial body, therefore it is obvious that collection of rent and other matters relating to tenancy will be looked after by plaintiff number two and plaintiff number three. In view of the discussion above, it reveals that ownership of plaintiffs is not disputed by the defendants. They have never objected about the ownership of the suit premises. On the contrary, their act of payment of rent in the name of Kanta Devi Jain established the fact that they have admitted the ownership of the plaintiff. As per Exhibit 3, defendant number one has been asked to attend the tenancy and to pay the rent in the name of the plaintiff number one. But in spite of receipt of letter from the plaintiffs, the defendant number one had sent the rent for the month of April and May 11 in the name of Kanta Devi Jain alone, not in the name of plaintiff number one. The defendants are aware of the matter relating to ownership and never denied ownership of Kanta Devi Jain. So this issue is decided in positive. Now, so this is regarding the entitlement of the atonement of the tenancy to the transferee owner. Now, paragraph 16, my lord, down below, the point of defaulter is dealt with. May I read it, my lord?
Yes.
The plaintiff has pleaded that the defendant has defaulted in the payment of the rent since April 2011 to August 2011 for rupees so and so. As such, the defendant is liable to be evicted and also paid for arrear rent. The defendant admitted that they paid the rent for the month of April and May 2011 in the court in the month of December
Who is the
2011.
defendant?
Yes, my lord.
The company.
It's a company, my lord.
Wait a minute.
The defendant admitted.
Who's the director?
One Utpal Rajans, my lord, he is a practicing advocate also.
I think I'll not take it. Try for some other thing. I've just noticed, that was why I was searching.
Okay, my lord.
Not because he is an advocate, he is
Initially,
being
it was in the-
being an advocate is not a problem.
no,
But,
we have not raised that point also.
I know him personally, that is why.
That is up to your lordship.
That is why.
Yes, my lord.
Not because advocate case we cannot take up, we can take up,
Lordship.
but it may not look good. Either this way or that way we decide, it will not look good.
Yes.
I think it should go for any other person. So it was all earlier accused by PK Dekar, Honorable Justice.
It was there. But in one of the matter, Justice Devashish Barua has taken up the matter and.
He can take, he may not have any person. I have a personal,
Yes, my lord,
I think it's right one before we spend more time. Yeah. Okay. Sorry. No. Photo. Narmo, Virat Kohli. Photo. Hey, really? Wait. Okay. They will for any other bit. We'll see that 2 o'clock. We'll rise now. I'm not feeling very comfortable because of the heat of. See that 2 o'clock. Yep. Before any other bit.
in the admission column, my lord, in the admission column.
Admission only.
Obligation, my lord.
Lordship, I have a very special,
Now we'll see that 2 o'clock.
or 2 o'clock,
We'll see.
no problem,
Not feeling comfortable. at all.
no,
Come on.
fine, fine.
Not anything from the
22nd of
August. My
20. What is this therapy about?
lord, I have filed one petition paying leave of the court to produce some documents, my lord, that they rejected, my.
You are repenting.
I'm the defendant, ma'am.
You filed your written statement.
Yes, if a written statement is filed, plenty of evidence is over. Thereafter, I have filed a petition for
Further document.
the document.
Taking leave.
Leave, my
That has been rejected.
rejected. My.
There is a joint prayer for adjournment. Considering the same. Matter is adjourned to be listed on 22nd.
22nd, my lord.
22nd of August.
22/8. Second line to paragraph 4.
My lord, there is interim order that may be continued.
Interim order prosecutor to continue to turn the router.
Obliged.
May I please, Lordship?
Yes.
Lordship, perhaps the service report is awaited, Lordship. Lordship, and Lordship, both the party want to negotiate this matter, Lordship. So this matter may be referred to the mediation, Lordship.
We can refer only after their appearance.
Yes, Your Lordship.
Let them appear, then you make this prayer, we'll consider.
Lordship,
When was notice sent?
17/5/23.
It was issued on 35. You have taken section 17/5. Deficit postal there were 16. From 16 to 17. Okay. Your name?
MM Zaman, on behalf of S. Samaria, Lord. Zaman.
MM Daman, learned counsel for the petitioner by referring to the office note has submitted that neither that the sole respondent that has referred to the office note Full stop, full stop. Office note dated 27/7/2023 reflect that neither AG card nor answer notice for the sole respondent has returned back. Full stop. The office note dated 35/2023 reflects that notices were issued on that date and deficit postal stamps were deposited on 1/6/2026. Full stop, para. Since more than a month has elapsed, para, the matter will be listed before the learned Lozima court to pass appropriate orders on deemed service. Full stop. The matter may thereafter be listed for orders.
Yeah.
Wait, this is your lordship. Lordship, this appeal was admitted on 23/2/22, but on that day, the stay was not, I do not know, somehow the stay order is not there. So lordship will take up IA civil number 2323 of
Yes, yes.
2020. Lordship, we need a stay and the
much is the
appeal is on quantum, lordship.
How much is the amount?
Amount is, lordship, 22,85,000.
They have appeared.
No, lordship, the office note dated 27/3/23 says that notices were sent to them, lordship. After that, there is no report.
What was the, this is the death case.
That case, lordship.
What was he doing?
He was,
He was a student
no,
going from his hostel.
mm, he reached, no, when he reached near the hostel.
He was going from his hostel on a motorcycle
Uh,
to bookstore. He was a student.
yes. A student of dental college, lordship. That's why the compensation is high, because the future. That's why we have challenged the quantum, lordship, because the amount given is 22 lakhs,
You,
taking his yearly income to be 1,80,000.
you may have to make the deposit.
Lordship, we can deposit 50% right now, lordship.
Hard. MSRT Mazumdar. I, the learned counsel for the applicant appellant who by means of this interrogatory application has paid for stay of the judgment and order dated 28/2018 passed by the learned MACT in Chukia in MSD case number 16 of 2016. Full stop. It is submitted that the challenge is mainly on the quantum and the connected appeal was admitted on 23/8/2022. Full stop. However, due to inadvertence, the prayer for interim relief was not pressed. Full stop. Our learned counsel accordingly submit that an interim order be passed staying the judgment. Full stop, sir. Considering the above and also the objective of the statute, this court is of the view that the judgment in question can be stayed on fulfillment of condition of deposit. Full stop. That accordingly it is directed that the impugned judgment and order date and award date that remains suspended subject to deposit of 50% of the amount in the registry of this court within a period of 2 months from today.
Highly obliged, lordship.
I send this.
And Lordship, in the appeal, Lordship, registry can be directed to, because they have not given any report after 27/3/23 on the service. On that day, the notices was sent. After that, March, April, May, June, now it is August.
Doesn't matter, there's a stay now, we would say, but 27/7. Task is 27/7, madam.
Office note 27/3/23.
No, there is a note of 27/7.
Acha.
Present.
So then we have to wait.
It was sent by district and session judge. Bihar. And records are also called for.
Hello.
This case I am appealing for the respondent number 1, 2, 3 and 4.
Yes.
That is regarding probate of the will. The appellant filed an probate case for the
Who is there? Mr. Esbora.
S. Bora.
Mrs. Esbora.
Mrs.
Or
Esbora.
Mr. Mrs. Who is Mrs. Esbora?
The morning she was there.
2006 matter.
Lordship.
Yes, who are you?
I am for the respondent number.
I understood.
Lordship.
How are you connected?
Lordship,
There's a will.
I am the legal. I am the legal.
Who had made the will?
Will was executed by Nalia Bora in favor of Damayanti Bora.
Damayanti.
Damayanti Bora, the appellant.
Okay, then what had happened?
Uh,
It was put to probate.
in respect, yes, in respect of 9 plots of land.
What is your connection with Nalia Bora?
I am the daughter of Nalia Bora.
You are a daughter.
Daughter of Nalia Bora. Nalia Bora had 2 wives. One is Bhogeshwari and one is Zonaki. He had 2 wives. He executed this will in favor of Damayanti. And after the death of Nalia Bora in 2004, the will was put to probate.
What is your mother's name?
My mother's name was Zonaki Bora.
You are the
Legally,
daughter of the
Zona-
second wife.
second wife.
Thereafter,
In this matter, when we received the notices from the Honorable Court, we filed objection. The objection was basically on the ground.
no, you had put to probate.
The will was the Damayanti put the will in probate.
Yes.
So we received notices from the court.
The appellant is Damayanti.
Appellant is Damayanti.
Okay, you are the respondent. Okay, then you received notice.
We
You
received
filed
notice.
objection.
We filed objection.
Who are you?
We are in the main
In the appeal?
appeal in the appeal respondent number.
No, not respondent. How are you connected with this? Your sons and daughters of Bhogeshwari?
Not Bhogeshwari, Zonaki.
No, Damayanti is the daughter of Jonaki.
Damayanti is the daughter of Bhogeshwari and Nalia.
Damayanti is the daughter of Bhogeshwari.
Bhogeshwari.
You said Jonaki right now. Damayanti. And you?
I am the daughter of Jonaki Bora,
Second wife.
second wife.
What is your name?
We are Nilimai Bora,
Lily Mai.
Nili N.
Lily Mai.
Gohati Bordoloi Hazorika,
And
Konoklota Deka Bora, Renu Bora Hazorika. I am representing
Four daughters,
four daughters.
four
There are
daughters of Nalia and Joraki.
Nalia and Jonathan.
You are the objector.
I am the object. So we filed our objection. Our objection was regarding that there are other legal heirs also in respect of Nalia Bora. They are not made party, and we said that Nalia Bora has not executed any will in favor of
That is on marriage. That you are questioning the will itself.
will.
And on procedure, you had raised the objection that other legal heirs not being made part.
Not been made.
Who are the other legal heirs?
There is a son Rupam Bora. He was not made party.
Son through whom?
Junaki Bora,
Your brother,
my brother.
Rupam.
Rupam. And another Kiran.
Yes.
She expired. She was a daughter from Bhogeshwari. Her husband was made party, but her daughters were not made party. Daughter of Kiran was not made party. In the issue number 2, it has been dealt with. Issue number 2 is, we'll make it clear, Lordship. May I read the issue number 2?
And the decision, your objections were accepted on both the count or one count?
No, both the.
Both.
Both the.
The validity of the will was also your objection regarding validity that was also upheld
Yes.
as well as on the grounds of not making proper party.
Yes.
Okay. On what grounds did you challenge the validity of the will?
Validity of the regarding health condition. That at the time of execution of the will, Nalia Bora was not in good health. In fact, before 4 days, he was released from the hospital.
4 days earlier.
4 days earlier, he was released from the hospital. The will was executed on 9/5/2000, and he was released from hospital on 5/5/2000. The doctor in which the hospital in which he was operated gave his evidence. DW1.
Now, after 5 days, can't he execute an will? What kind of ailment he had?
He was suffering from cancer, and he was operation was done.
He was in his mental condition is required to be seen.
He was 80 years. He was 80 years old at the time of execution of the will, and 84. Sorry, so lots of 80 years old. Then he was prior to 5 days. He was released from the hospital. So
maybe, but until he was mentally unstable,
not so.
A person can be physically, he can be in a bad state, but still he can. What is a will? Will is an expression of your interest, your intention. You are not required to do anything physically.
But our submission was that, Lordship, he was not medically fit at that time, and
medical fit will have two connotations. One is mental fitness, one is physical fitness. We are only on the aspect of mental fitness. It is the intention, whether you are mentally sound to make a will in somebody's favor. Your physical condition will hardly come into.
And another aspect that the witness who has deposed in favor of the appellant Lordship, he was an interested witness. He was possessing some land, and therefore, on these counts, the probate case was dismissed. And in fact, non-gender necessary party is an important issue.
Non-gender also will come, but now can you do you know this your colleague on the other side?
I know, but phone number. I do not have that phone number now.
2006 matter we cannot adjourn. Anyone knowing her? Mrs. Esbora.
Susita. No, but mobile number is not available.
We have to day after. Day after it is not there, then it is fast. And appears for the appellant on call. Was she there in the first house?
She was available in the past.
Not being able to recollect. Whereas D. Chaudhary, Senate Council is present for the restaurant numbers 1 to 4.
One.
So, this appeal, why is it interested case? It is not an interested appeal.
That time, I think 2006 was the practice.
It's an interested appeal. It
Maybe not.
can't be interested case. We are not exercising original jurisdiction. This case is of the year 2006. However, in the interest of justice, another opportunity is granted, and this case is directed to be listed again for hearing on Thursday, day after tomorrow. Date. It is however made clear that in case there is non-appearance from this court would be constrained to pass the appropriate order. 5 to 11 justice has been served. Okay.
Performance.
Yes.
May I please, Your Lordship? Lordship, the present second appeal is preferred against the judgment and decree dated 3/11/2009 passed by the learned civil judge number 1 Kamrup, my lord, whereby
Yes.
whereby the judgment and decree dated 20/03/2006 passed in title suit number 3/2004 by the learned civil judge junior division was set aside, my lord. A judgment of reversal, my lord. And this appeal was the present.
Who are you? You are the plaintiff.
I am the plaintiff, my lord. I am the plaintiff.
Yes.
Despite service of
Plaint was for?
my lord.
Suit for?
Suit for my lord. Several prayers were there, my lord. First of all, my lord, for possession of schedule,
Let's see your plaint.
my lord. Vernacular starts from my lord.
Not the vernacular. Accurate copy.
But translation part, I have doubt, my lord. It was properly translated or not, my lord. Plaint starts from page 11, my lord. The prayer portion is at page 19, my lord.
There are 96 defendants. There are
96 defendant, my lord.
defendants.
96 dependent, my lord, but the main dependents were dependent number 1 to 6, my lord. And others were performer dependent.
Suit for amicable partition.
My lord.
Partition,
Decree for possession and permanent injunction, my lord.
possession, possession recovery or confirmation?
My lord, possession recovery, my lord. No, my lord, possession confirmation, my lord.
Confirmation.
Confirmation, my lord.
Yes, tell us what has happened.
My lord. On 12/5/2010, the present appeal was admitted, my lord.
No, no, what has happened in the suit? How are you connected? Who are you?
My lord, prior to going to the background of the suit, my lord, yesterday when I was preparing the case, my lord, I felt that there might be some other additional substantial question of law required to be framed, my lord. So I have prepared, if your lordship permits me, may I submit those?
First, let us have the fact. Then
My lord. My lord. My lord, prior to going to the suit, my lord, I have to go to the background, my lord. The original owner of the land was the father of dependent number 96, my lord.
Yes.
He was owner of a plot of land measuring approximately 6 bighas, my lord. More or less than 6 bighas, my lord. So after his death, my lord, his wife, the mother of the dependent number 96, my lord, she became owner of 1/8 share as per Mohammedan law, my lord. That share.
What is the name? How is the mother of the defendant number 96? She is a party.
She died prior to institution of the suit, my lord. Golazan Begum, my lord. Thereafter, my lord, since there was no son, they have.
What
no
is the
other
name of the
son.
father?
My lord, Hanif Ali, I think.
And mother who has passed away?
Golazan Begum, my lord.
Golazan.
Golazan.
Yes, thereafter.
My lord, since there is no son of Hanif and Golazan, my lord, so the dependent number 96 has become owner of 2/3 portion of the said land, my lord, as per the Mohammedan Hanifi law of inheritance, my lord.
Oh, 96 is a lady.
96 is a lady, my lord.
Kulzan.
Kulzan, my lord.
Kulzan, okay. Kulzan became what? How much did she get?
She will get, my lord, as per Mohammedan law, she will get 2/3 of the property, my lord.
2/3 of entire property.
Entire property, my lord. After giving away the 1/8 share first to the wife, my lord, see the residual property which remains, my lord, on that, my lord, the 2/3 property will be devolved upon the
Daughter.
daughter, my lord.
And 1/3?
1/3 that can be claimed by anyone, my lord, by their other relatives, my lord, as per the Hanifi law, my lord. That was not claimed, my lord. So as per Mohammedan law, 1/8 share belongs to the wife, my lord.
Golazan.
Golazan, my lord. So if we simplify it, the 6 bighas of land, my lord, it will become 600 lesas of land, my lord. So the share of the mother would be, my lord, approximately 75 lesas, my lord.
1/8.
1/8. 6 bighas, approximately it will be 75 lesses, my lord. After these 75 lesses, my lord, the share of the daughter would be 350 lesses, approximately, my lord, more or less 350 lesses, my lord. 2/3 share, my lord.
That means 2/3 of 525.
Yes, my lord. 350 lesses, my lord. Total, there will be
300 and
350 lesses, my lord.
okay.
Approximately, my lord. This may increase or decrease, my lord. Proper. So total land would be, my lord, 425 lesses of land, my lord, which is going to be distributed amongst these two ladies, my lord. Now, my lord, during the lifetime of her mother, my lord,
Gulajan.
Gulajan, my lord, the defendant has relinquished her right in favor of her mother, my lord.
Defendant 96.
96 has relinquished her right
By
in favor of her mother, Gulzan Begum. Sorry, my lord, it is not Gulajan, it is Gulzan Begum.
by what? By a deed.
By a relinquishment deed, registered relinquishment deed, my lord. And this deed is in fact admitted, my lord, by the defendant. By deed number 1966/1963, my lord.
Okay.
Now, my lord, thereafter, Gulzan has married Samsul Ali. The mother of defendant number 96 remarried, again married one Samsul Ali.
Okay.
And when, my lord, when Gulzan died, my lord, as per the Hanifi law, my lord, Hanifi law of inheritance, my lord, Samsul became the owner of 1.5 share of the Gulzan Begum property, my lord.
Half share.
Half share, my lord. He will get half share as per the Hanifi law, my lord. Since there was no issue between Gulzan and Samsul, my lord. And rest half share would devolve upon defendant number 96, my lord, as per the law.
But she had already relinquished.
Relinquished in respect of her share, but she will have share on her mother part. The mother become absolute owner of the total 425 lectures of land, my lord. So half share would go in favor of her new husband after her death, and half share would go in favor of Gulzan, my lord,
Okay.
which is approximately, my lord, 2 bighas something, my lord. Then, my lord, this Samsul Ali, subsequently, when Gulzan died, my lord, he married the plaintiff number 1. He married plaintiff number 1, and plaintiff number 2, 3, and 4 are the sons and daughters of Said Samsul Ali, born out of the wedlock between plaintiff number 1 and Samsul Ali, my lord.
What is the name of plaintiff number one?
Safia Khatun,
Safia,
Safia,
Safia.
Safia Khatun, my lord. After death of Gulzan Begum, Samsul Ali married Safia Khatun, my lord. Subsequently, my lord, what happened? In the year 1967, my lord, the defendant number 96, my lord, this is very important, my lord. Executed a sale deed in favor of the plaintiff number one. That is registered sale deed number 3766/1967, my lord.
Plaintiff number one.
In favor of plaintiff number one by Gulzan Begum, defendant number 96, my lord.
The daughter.
The daughter of the original owner, my lord. So, my lord, and this sale deed,
Registered deed.
registered deed, my lord, registered, and this deed is in fact admitted by defendant number 126 and defendant number 96 also, my lord. She has admitted. Now, my lord, through this sale deed, my lord, she has transferred 2 bighas, 2 kathas, 2 bighas, 2 lechas of land in favor of
Safia.
Safia, my lord.
2 bighas,
2 lechas.
2 lechas.
2 lechas of land. Meaning thereby, my lord, now she does not have any more land in the schedule mentioned below, my lord. Subsequently, what happened, my lord, in the year 1992,
Hmm.
in the year 1992, my lord, it is pertinent here. I forgot to mention one thing, my lord. Later on, my lord, one part of the land which was sold to the plaintiff number one, she has sold to someone else, my lord. That is not
Relevant.
relevant. So she is now in possession of the schedule Go land, my lord.
Plaintiff.
Plaintiff, my lord. The plaintiff,
Plaintiff appellant.
plaintiff appellants, my lord. Schedule Go land, which was purchased by her, my lord.
Hmm.
That is, my lord, one bigha, 2 lechas of land, my lord.
Yes.
Subsequently, what happened, my lord, in the year 1992,
Hmm.
the defendant number 1 to 6, by virtue of a sale deed, not a sale deed, but 2 sale deeds, my lord. One is registered, my lord. Another one is unregistered, my lord.
Okay.
Executed by the defendant number 96 in favor of defendant number 126, my lord, tried to disturb the peaceful possession of the plaintiffs, my lord. From the schedule
These sale deeds, 2 sale deeds were executed by whom?
by defendant number 96, my lord, Gulzan,
In favor of defendant number 1 to 6.
1 to 6. My lord.
Hmm.
One is registered, my lord. Second one is unregistered, my
Hmm.
lord. My lord, through the registered sale deed, they have claimed, my lord, in the schedule Kho, my lord, the land is shown as 2 land, my lord. Through the registered sale deed, my lord, they have claimed their ownership over the part one land, my lord, that is covered by DAG number 543, land measuring 1 kotha 2 lechas, my lord.
Now,
DAG number 543.
Hmm.
1 kotha 2 lecha, my lord. And through the unregistered sale deed, my lord, the dependent number 1 to 6 has claimed ownership over a plot of land measuring 1 kotha 12 lesser covered by DAG number 502, my lord. Since they are trying to dispose us, my lord, 145 proceeding was initiated before the concerned executive magistrate, my lord. Which was numbered as 266 AM/92.
one 45 petition was filed by you.
145 petition was filed by me, my lord, by the plaintiffs, my lord. And
Okay.
in the said petition, my lord, the learned executive magistrate has observed that I am in possession of the scheduled land, my lord. The said observation was challenged in the Court of Session Judge by the defendant number 1 to 6, my lord.
Division.
Revision, my lord. And the matter was sent back to the Court of Executive Magistrate for reconsideration.
Remanded.
Remanded, my lord. Remanded for reconsideration, my lord. And I order dated 11/12/1999. The matter was closed by the executive magistrate directing the parties to approach the appropriate forum.
Civil court.
Matter. Civil court, my lord. Then subsequently, my lord, the plaintiffs have filed title suit number 12/2000.
Hmm.
12/2000, my lord. But since there was some technical defense, my lord, the plaintiffs have filed a petition to withdraw the case with liberty, my lord.
Yes.
With liberty to file a press, my lord. The said prayer was allowed. I order dated 23/12/2002, my lord. My lord, I have a little confusion regarding this date, my lord. Perhaps it is 23/12/2003, my lord. I don't have the
Okay,
exhibits with me, my lord. This order was produced before the learned trial court, my lord. So subsequently, my lord, the present plaintiffs have filed title suit number 3/2004.
the other side has chosen not to appear.
Yes, my lord. Although they have chosen not to appear, my lord, but they are constantly trying to dispossess me, my lord. Mainly what happened, my lord,
Where is the last office note?
my lord, is no.
Did you take press steps after 14?
My lord, 10 January, my lord, press steps was taken, my
And
lord,
January of,
2014, my lord.
no, after the 2014 matter had come.
There was, my lord, some observation. Yes, my lord, there was a Lozima court order, my lord. Uh, Service upon respondent number 1 to 9, 11 to 44, 46 to 67, 71 to 84, and 86 to 96 have been received. Service in respect of respondent number 10, 45, and 68 not yet received, my lord. And the respondent number 10, 45, and 68 perhaps been later on strike off by the earlier council, my lord. In the trial court also, my lord, the other respondent except respondent number 1 to 6 and respondent number 96, other respondent did not contested the suit, my lord.
Okay, 45 and 68 has been struck off by an order of 10, 11, 5 to 2015. And so far as 10 is concerned, That was by inadvertence.
Typographical mistake, my lord.
That is to be shown off, and it is in respect of response number 9.
My lord.
And others have been served.
Others has been served, my lord. That was, there was a lodgement court order, my lord. All the defendants who have contested the suit has been served, my lord.
Okay.
In the,
When you had filed the prayer for withdrawal with liberty, that was allowed
that was
on 23/12/2002 or 3.
three, my lord. Perhaps
Thereafter, you filed a fresh suit.
fresh suit, my lord.
When?
Fresh suit,
Fresh suit title number,
fresh suit number, my lord, 3/2004, my lord.
title suit,
Title suit number 3/2004, my lord. In the court of civil judge,
then
junior,
that means it should be 3 other, because it will not take 1 year for filing a fresh suit.
my lord,
It should be 23/12/2003 perhaps.
three, my lord, perhaps.
Yes.
In the
Now
said
this-
suit, my lord,
Hmm.
after receiving of the notice, my lord, only defendant number 1 to 6 and defendant number 96 have appeared, my lord, and they have filed their written statement, my lord.
Defendant number 1 to 6.
1 to 6 and defendant number 96, my lord. The seller and the purchasers. They have appeared, my lord.
Yes.
My lord, during the trial, my lord, the plaintiffs have examined 6 witnesses. 6 witnesses examined, my lord.
Hmm.
Including all the plaintiffs, my lord, and 1, my lord, co-partader, my lord.
How many plaintiffs were there?
My lord, 5 plaintiffs are there, my lord. Plaintiff number 1 is the mother, and others are the sons and daughters of plaintiff number 1.
Yes.
The plaintiff side had exhibited uh, 5 documents marked as exhibit number 1, 2, 3, and 5, my lord. And mark the registered certified copy of the registered deed of sale, my lord, which was executed by the defendant number 96 in favor of the plaintiff, my lord. Admitted document, my lord, that was marked as mark A, my lord.
Yes.
Mark B is the certified copy of the registered deed, the deed of relinquishment, my lord, whereby by the, my lord, the Defendant number 96 has relinquished her right of the share of the property in favor of her mother, my lord. That is also admitted document, my lord.
This relinquishment was by 96, isn't it?
My lord, 63,
No, defendant number,
dependent number 96, my lord.
exhibit B,
Like not exhibit, my lord, mark B.
mark B.
Mark B, that is confusing, my lord. First time I came to exhibited certain documents, my lord. Well, certain documents were marked as mark A, B, and C, my lord. Why they have marked those documents as A, B, C, not
Was it
exhibited?
proved or not? In the evidence, was it proved?
No, but these documents are admitted documents, my lord.
No, admitted, but other side has admitted.
Yes, my lord. In their own written statement, my lord, 1 to 6 and dependent on 96 have admitted these documents, my lord. And Mark C is the certified copy of the subsequent registered sale deed, my lord, of 1992, which was executed by dependent number 96 in favor of the dependent number 1 to 6.
What is this deed?
Registered sale deed number 944/1992. Executed by Fuljan Bibi in favor of Samsul Haq and others.
Yes.
This document also exhibited, although we have marked it as mark C, my lord, but this document was subsequently exhibited by the dependent number 1 to 6, my lord.
Yes.
As the exhibit number, my lord, exhibit number 1, my lord. Exhibit number A, my lord. Now, if your lordship may kindly come to page 38 of the memo of the appeal, my lord. Here, my lord, this is the written statement filed by the defendant number 1 to 6, my lord. Starts from page 36, my lord.
36.
Yes. The WS filed by the dependent number 1 to 6 starts from page 36, my lord. At para 11, page 38, my lord. They have admitted these two documents, which were been marked as mark A and mark B, my lord. Para 11 starts at page 38. Relevant portion is at page 39, my lord. First paragraph. At second paragraph, they have admitted that Samsul Ali again married Gulzan Bibi. And after her death, my lord, he became absolute owner of, in respect of his share, my lord. Then at paragraph number, third paragraph, my lord, they have admitted that Fuljan Bibi has, that dependent number 96 has sold a plot of measuring 2 biga, 2 lechas, my lord.
Registered with
Restudied, my lord. This is,
3766.
yes, my lord. This is admitted, my lord.
You said it's a judgment of reversal.
Yes, my lord.
It was decreed in your favor initially.
It was initially decreed in part, my lord. Partly in my favor, my lord.
You did not prefer any appeal.
No, my lord. Because I was only concerned about schedule and goal land, my
Go.
lord. And interestingly, my lord, in this case, my lord, neither the defendant number 126 nor the defendant number 96, who has appeared and filed a WS, my lord, contested in respect of the land mentioned in schedule go, my lord. That is an admitted fact, my lord.
They did not appear.
They have appeared, but never contested, never filed any claim in respect of land mentioned in schedule go, my lord. Hereby, they have admitted that that schedule go land belongs to me, my lord. And this observation has been given by the learned trial court also, my lord. Now, if your lordship may kindly come to WS file by defendant number 96, my lord. That starts from page 48, my lord. At paragraph 10, page 50, my lord.
Page
Page 50, 50. 50, my lord. Paragraph 10, my lord. He herself had admitted execution of those two documents, my lord. The deed of relinquishment, my lord, and subsequently the
Please
deed of
read.
sale, my lord.
Please read paragraph 10.
Yes, my lord. That with regard to the statements made in paragraph 5 and 6 of the plain, the answering defendant states that after the death of her father, she being only legal heir had inherited the entire property of her father, my lord. This is wrong, my lord. As per Muhammad Allah, she cannot inherit the entire property, my lord. And subsequently, she has relinquished the land measuring 3 bigha, 1 lesser 2 poas of land of Dag number so and so, KP pattern number 71 in favor of her mother, Gulzan Bibi. And she had sold away another plot of land measuring 2 bigha, 2 lessers of Dag number so and so of KP pattern number 71 to the defendant number 1, my lord. She has admitted, my lord.
Then what about the last line?
She remained
No, plaintiffs have never acquired.
right title interest over the other land than the land relinquished and land sold to the plaintiff number 1. My lord, as per Hindu Succession Act, the daughter and mother are the class 1 legal heir. They are entitled to inherit equal share, my lord. If mother dies, then automatically the daughter will inherit the whole property, my lord. But in case of Mohammedan law, my lord, the inheritance law is different from the Hindu law, my lord. On the date of death of her husband, my lord, the wife becomes entitled to 1/8 share only, my lord. Intestate property, my lord, 1/8 share belongs to automatically comes
Wife.
in belongs to the wife, my lord.
Hmm.
Rest 7/8 property, my lord. Out of that, my lord, if there is one son and one daughter, the son will get 2 shares, my lord. The daughter will get 1 share, my lord. And if, my lord, there is no other sons and daughters, my lord, only one daughter, my lord, she will get 2/3 of the remaining property, my lord. So it is clear, my lord, she does not have any other land. She cannot claim more land than this portion, my lord.
Hmm.
Now, my lord, she has also admitted the Samsul Ali, the husband of the plaintiff number 1 and the predecessor of plaintiff number 2 and 5, my lord, who married her mother subsequently, my lord, has inherited her share, the share of her mother, my lord. When, my lord, suppose in Mohammedan law, my lord, a man marries a woman and there is no issue between them, my lord, then the husband will entitled to get half
Half.
of the share, my lord. And if there are sons and daughters, my lord, then he will get 1/4 share, my lord. The residue is given in the mullah's if your lordship.
Mohammed Lord. Yes, please.
My lord, in this book, my lord, page 68, my lord, this book, my lord. Hanafi law, chapter Roman 7, my lord. Hanafi law of inheritance, my lord. Chart 1, my lord.
Just a minute. Yes, Hanafi law of inheritance.
My lord. Chart 1, my lord. Table of share, my lord. Sunni law. In respect of my lord, people, most of the people in the eastern side of the India, my lord, they are governed by, my lord, Sunni law, my lord, Mohammedan.
Yes.
Here at my lord, serial number 3, husband. Mhm. Normal share at column number 2, my lord. It has been shown as 1/4.
Yes.
Column number 3, condition under which normal share is inherited. That is, my lord, when there is a child or child of his son. Your lordship has got it. Then at column number 4 may kindly be seen, my lord. 1.5 when no child or child of a son H1S, my lord.
Column number?
Column number 4, my lord.
Yes.
1.5 when no child or child of a son.
H1S means
My lord, 1.5, my lord. Column number 4.
no, that's what is H1S?
First degree of legal years, my lord. My lord means his son, my lord. My lord, that means the son born out of the wedlock, my lord.
Condition. Number
Born out of the wedlock between the husband and the wife, my lord. Since, my lord, in the present case, there was no child, my lord. So, Samsul Ali will get 1.5 share of his wife, my lord, Gulzan Begum, my lord.
Since there were no children, your submission said Samsul will get half.
Half, my lord, of her wife's property, my lord. This is why.
How long will you take? Take some time.
It will take some time, my lord.
Others may no scope. Let's talk about which matter.
Number 11,
11 as
arbitration appeal.
arbitration appeal against.
You
are for the railways.
Yes, I'm for the railways, appeal by the railways. Award was passed in railways favor, subsequently set aside by the
34.
34.
You're in 37.
Yes, my lord. My lord, if it is otherwise not inconvenient, can it be taken up on Thursday?
Appeal of which year?
2020.
20. There are old appeals actually. This is a very old appeal. One we have already fixed. 2006 matter. You have seen already.
In that case, my lord, 22nd of August,
Are there evidence?
my lord.
Are there evidence in your case? In the arbitration?
Yes, my lord. Basically, the award was a claim for the contractor was rejected, and the termination was also held to be valid. And the
34 has upset the award.
yes, totally. Number one, saying that the termination was not good, and secondly, all claims were allowed without any reason.
But termination, it was terminated prior to the extended period, and there was counterclaim. Counterclaim was allowed without affording opportunity to file written statement against that counterclaim. So
By the arbitrator.
by the arbitrator.
Counterclaim we can, for the time being, we can ignore. What about,
But also, Lord, it was extended.
what about the interference with the findings? 34 report. 34
Interference is
got
that,
very
Lord, it
limited
was
role.
extended. Earlier
What are your
completion
grounds
date
of-
was
What were your grounds in 34?
ground was that it was extended, and prior to that extended period, about 5 months prior to the extended period, my lord, without showing in reason, it was terminated.
No.
That is one, that was one ground. And another was that
Okay, we'll have
counterclaim.
it, we'll have this someday. Today, not today.
Some other day.
My lord, the counterclaim, what was allowed, that could have been allowed without the counterclaim also. All claims of railways under the counterclaim were rejected. Only the performance guarantee and the security deposit were allowed to be encashed. That would
That's
have
a
been,
part of the law.
yes, my lord. That so
That is,
For that,
that is-
did not make a claim.
yes, my lord, is one aspect. And the other aspect, that the case that they were termination was done during the extended period, there is a finding on record by the tribunal, arbitration tribunal, that till that day they have not even commenced the work.
within that extended period also, the work was of constructing a tunnel in the Manipur section. Manipur Jiribam section. So on the date of termination, they have not even started the tunnel work.
But although
So-
that is
So
held by
it is a
arbitrator,
finding of fact based on record by the arbitrator, which was upset by the
Could you have tell us a date?
22nd of August. Or 11th of August is also.
11 Friday, 22nd will be,
22nd will be a Tuesday.
yeah, in it.
Third, that's the property count appearing for the date is. Whereas the fellow has is present for the.
Respondent,
sole
sole
respondent.
respondent.
Paucity of time may not allow the matter to take up. As agreed to by the party. Case for hearing on 22nd of August.
Much better.
No, I think 16 also may kindly be taken on next week even, right? It is actually 18 matter.
Dates will give. We only wanted any matters for urgently nature.
Well,
Still give the return to smile.
item number 7, my lord, next matter is that railway accident matter, which your lordship had already heard, my lord, but probably it has been fixed for dictation of orders. So, my lord,
The doctor case,
yes,
eyesight.
I said.
What was that?
But
What-
it was granted to the respondent to take instruction from the client,
Whether
whether
the-
the doctor is alive or
Yes,
not.
yes, yes.
So I have taken a consent from the client, my lord, that the doctor is alive, my lord. So my prayer is, my lord,
We'll have it day after tomorrow. We'll pass order.
Yes.
In your case. Just remind us, do you remember that case? Item number
item
7.
number 7.
7. Both the learned counsel, the B. Sharma for the railways, as well as M. Sharma for the claimant. Claimant have submitted that instructions have been received for Sapara list on Thursday for hearing.
Deeper.
Malad, item number 12. I am for the respondent claimant or MSc appeal matter, Malad. Malad, in that case, Malad, in this case, Malad, the tribunal was directed to make the payment by the insurance company and to recover it from the owner. But my lord, the appellant insurance company, my lord, by filing this appeal, my lord, saying that, my lord, they want to take some bone from the owner of the vehicle. Whereas, my lord, law is settled, my lord, they have to pay first, my lord, then, my lord,
Pay and recover.
pay and recover, my lord. And my lord,
Who are you? You are the claimant.
I am for the claimant, and my lord, while admitting this appeal, my lord, 75% was directed to be deposited. They have deposited. I have filed the withdrawal application, but they are not allowed. Like they were always insisting on final disposal. So my
We'll
lord,
allow
I am
that.
suffering from
We'll
since
allow that.
2015.
You file an IA, will allow
I
that.
have already filed, my lord, and the IA is also pending.
Who's for the other side? Madam,
Yeah, this is on the Nandapan case, lordship. We want the pay and recovery to be as per Nandapan. So lordship, that is the,
after all, claimant, they,
lordship, I understand, but it's already in hearing stage, lordship. Can we finally heard and disposed of?
Lord, since my lord filing of that IA, my lord, they are always insisting on here, my lord. By saying Nanjappa, after Nanjappa, my lord, several judgments have passed, my lord.
appeal has been admitted, you are required to pay deposit.
Deposited, my lord, but I am not allowed to withdraw.
Will allow that.
Lordship, let me call my senior, lordship.
No, we'll not have it. They will have it day after tomorrow. We'll pass orders for allowing. Be
On
prepared
Thursday, lordship.
Thursday,
Lordship,
or even tomorrow,
tomorrow.
whenever you. Tomorrow or day after. Whenever. Day after,
I am ready, my lord, any
day
day.
after, huh? Possibility of time, day after. Item number
Item number 12.
12. Paucity of time did not permit the matter to be taken up today. Your name?
M. Dottam.
Three M. Dr. Leonard Counsel for the claimant. Claimant
Claimant.
one.
One.
However, submit that to an amount has been deposited in this court at the time of admission of the appeal, till date, nothing has been released to the claimant, as a result of which he or she is suffering. The Learned Counsel accordingly prays for an urgent order for releasing the said amount full supply list on to for consideration.
Deeply.
Yeah, please, Your Lordship. Item number 9, my lord, fixed for hearing, my lord. Matter may be fixed on the 22nd.
He'll give a date, don't worry. Let us continue with this. Yes,
Really?
Mr. Sharma.
Yes, my lord. Then your lordship may come to serial number 4, my lord. Why?
All right.
1 HCR, my lord.
Yes. Yes.
Regarding daughter, my lord.
Seven.
7, my lord. Half. Now she will get half, my lord, of her mother's property, my lord. This is the table of distribution of shares, my lord. Now, my lord may come to page 51, my lord, of the memo of appeal, my lord. May I read it, my lord?
One. $51.
51, my lord. Second paragraph, my lord. May I read it, my lord? Though the register, it should be through the registered child deed number 3766/67, the answering defendant has sold the plaintiff number 1 a plot of land measuring 2 acres to lessors covered by DAG number 414, 415, 516, 526 of KP Patla number 71, my lord.
Yes.
Hereby, my lord, she has admitted that I have land in DAG number 526, my lord. Now, if your lordship may kindly come to the schedule G land, my lord. That is at page 21 of the memo of appeal, my lord. A plot of
Five-
land,
526.
my lord, 526, my lord.
But 526, this 2 bigha 2 letter, which you have
Out of,
just-
my lord, 2 bigha
this
to
one, this 2 bigha 2 letter is in 4 ducts,
in 4 ducts, my lord,
4 ducts, including 526.
526,
That
my
does
lord.
not, may not
But-
mean,
This is my own land, my lord, purchased by the plaintiff number 1, my lord. But subsequently, what happened, my lord? The plaintiff number 1 has again resold 1 bigha out of that land to someone else, my lord. The lady name is somewhere else, my lord. Mm. Yes, my lord. At paragraph 2, my lord. My lord, that is why I am saying that I cannot trust the translated part, my lord. The vernacular says like this, my lord. Paragraph 2. নিম্ন গ তফসিল বর্ণিত জমি 1 নম্বৰ বাদী নিজাত খৰিদ স্বত্ব দখল জমি হয় উক্ত জমি সহ মুঠ 2 বিঘা 2 কঠা 2 লেচা জমি 1 নম্বৰ বাদীয়ে 96 নম্বৰ বিবাদী ফুলজান বিবিৰ পৰা গত 20/10/67 ইংৰাজী তাৰিখে 3766/67 নম্বৰ ৰেজিষ্টাৰ্ড দলিলৰ দ্বাৰা খৰিদ দখল লৈ শান্তিপূৰ্ণভাৱে দখল ভোগ কৰি থাকি ৰেভিনিউত নিজৰ নাম জাৰি কৰি লৈছে পিছত উক্ত খৰিদ জমিৰ মধ্যে 1 বিঘা জমি 1 নম্বৰ বাদীয়ে someone else গোলাবানু বিবি my lord বিক্ৰী কৰি তেওঁক দখলী স্বত্ব সমজি দিয়ে আৰু সেই মৰ্মে গোলাবানু বিবিৰ নামত নাম জাৰি হয় and my lord kindly come to page 37 my lord 37 my lord
Yes.
paragraph 7 my lord This is the-
WS by 126,
my,
part
yes
of WS by 126.
yes my lord may I read it my lord
Paragraph 7.
yes my lord may I read it that with regard to the statements made in paragraph number 2 of the plain the answering defendant begs to offer no comment as the said Go schedule land is not their land and they are not concerned about any dispute relating to the said land. This is the statement of defendant number 126, my lord. Now, your lordship may kindly come to page 49, my lord. The WS filed by the defendant number 96, my lord.
Page,
Page 49, my lord, paragraph 7, my lord.
this is the different number.
96, my lord. 96 or probably 95.
Let us not confuse with the numbers.
My lord,
210 has been written as a, let the number be
My
same original number.
my lord. May I read it, my lord?
Yes.
That the statement made in paragraph 2 of the plaint are correct. And the answering defendants hereby admit the same. He has clearly admitted that she has no right over schedule Go land, my lord.
Where is the schedule in your plaint in the vernacular?
My lord, at page 34, my lord.
Go, yes, 34. Court of Civil Jamiর মধ্যে 556 নম্বর ডাগর মোট
1 বিঘা দুই লেসা। 1 বিঘা I have already sold to someone else, my lord. Golajan or something name. Yesterday, while I was going through the translated part of the plaint, my lord, I am not saying that I am good in English, my lord, but this translation is horrible, my lord.
Now, what is the controversy now? You said that the statements made in paragraph 2 are uncontroverted, rather admitted.
Yes, admitted. my lord.
Two relate to schedule Go.
And in fact, my lord, in respect of schedule Kho and Go, my lord, regarding dispute is regarding mainly is regarding schedule Kho, my lord. Part 1 and 2 of schedule Kho, my lord. Where they have tried to encroach the land, my lord, by virtue of the registered and unregistered sale lead, my lord. Schedule Go, I have also claimed for possessory right, confirmation of possession, my lord. That was decreed in my favor, my lord. Now, my lord, while deciding the appeal, my lord, the learned appellate court has interfered in this observation also, with regard to this observation also. When there is no case, my lord, they have admitted, my lord, that we have no case. with
You're only
regard to
agreed
schedule-
by the Go portion now. You're only agreed by the confirmation.
No,
portion.
my lord, I am agreed by confirmation of
The interference in the confirmation thing.
confirmation,
At the, in the appellate, second appellate case.
my lord.
For the other part.
And
you
the
are
confirmation
abundant.
stage, and also, my lord, regarding the observation regarding the sale deed, my lord, registered sale deed, my lord. Registered sale deed also, the learned trial court has observed that it is void, my lord, since the defendant number 96 had no land on 1992. In view of the
But you are not agreed by the observation of the trial court so far as schedule Kho is concerned.
I am agreed, my lord.
You did not file appeal.
No, trial court has decreed in my favor, my lord.
Kho
Yes, my lord. Kho has been decreed in my favor, my lord.
and Go.
Go is also decreed in my favor, my lord. mainly dispute with regard to the ownership is raised by the defendant in respect of the call land, my lord. The learned first appellate court should have limited itself to the schedule call land, my lord. But instead of doing so, they have interfered the observation made by the learned trial court in respect of Go land also. my
Now, what was the grounds taken in the appeal so far as Goa is concerned, in spite of
My lord-
you having shown that there are admissions?
My lord, ground sir, my lord, yes, my lord. Title appeal,
We'll continue day after tomorrow.
if, then my lord, at two, my lord, second half, my lord. First half, I have matter at CBI, my lord. If witness comes, then it will take some time, my lord.
Have it. Tuesday one. Thursday. Thursday, we'll look at the file also. Huh? Who's matter with? So, okay, now.
If your lordship permits me, may I submit those additional substantial question of law, my lord?
Now, let us first finish the fact,
My lord.
then. Sit here. I'll leave to more down.
Perhaps on Thursday, your lordship and on last occasion said that your lordship might have some interviews.
No, so those are over.
Okay.
Thursday, fact.
Thursday at 2 PM, my lord.
It will be listed, will not say 2 PM, we'll try to have it.
Because in the first half, I might.
Okay, we'll accommodate. Huh? Not putting it.